June June 14th is the kickoff for summer reading at the Conshohocken Free Library and at the other branches of the Montgomery County library system. You can track your reading on Beanstack, beanstack.com, which is a great resource for tallying your daily reading and winning some badges and doing challenges, which will automatically enter you into a raffle for prizes at the end of the summer. We also have a variety of other programming. We'll be doing weekly crafts and bi-weekly craft sharing. And so you can find more information at our website at, let's see, MNL, oh no, I'm on the spot. I don't know our website. mclic.polarislibrary.com.
Great. Thanks, Harry. So hello, everyone. Thank you for joining us this evening for our PMC Shares presentation on landlord-tenant affairs. My name is Daniel Parsons, and I work as an AmeriCorps Vista at Pennsylvanians for Modern Courts, a nonpartisan group that strives to educate Pennsylvanians about our courts and how to navigate them with confidence. Tonight's presentation will cover the ins and outs of the rental process within Montgomery County, how to resolve conflicts in housing situations, and will provide resources available to both landlords and tenants alike. This event is brought to you by the Conshohocken Free Library and is part of an ongoing legal education series, of which future programming on estates and family law will be held later this summer and in the fall. We'd like to extend our gratitude to Harry and his team for letting us present to you tonight, and to the legal aid of Southeastern Pennsylvania for co-hosting this event. As a reminder, this program is being recorded and will be posted at a later time so that folks who couldn't make the program this evening can refer to it later. Throughout the program, you can pose questions within the chat feature below, and there will be a Q&A portion towards the end of the presentation. So joining us this evening is Deborah Gross, President and CEO for Pennsylvanians for Modern Courts, and Michelle Dempsky, an attorney at the legal aid of Southeastern Pennsylvania, based within Montgomery County. So without further ado, I'll turn over to our presenters to introduce themselves. Debbie, if you'd like to start.
Thank you, Daniel. I'm Debbie Gross. I'm the CEO and President of Pennsylvanians for Modern Courts. We are an organization focused on access to the courts, helping people understand the courts, not be afraid of them. And we're focused on reforming the courts and modernizing the courts. So this program is one of a series that we do in Conshohocken across the state. And also, I just want to say thank you for coming and welcome. Michelle.
Thank you very much, Debbie, and thank you, Daniel. My name is Michelle Dempsky. I'm a landlord-tenant attorney with Legal Aid of Southeastern Pennsylvania. It provides free legal services and advice to low-income individuals in Montgomery, Bucks, Chester, and Delaware County, Pennsylvania. We also participate in a number of programs, including eviction prevention initiatives. My focus is on landlord-tenant law, although we tend to represent clients in a large variety of areas that we can get into more later, or you can visit our website to learn more.
Great. So we're going to go through this presentation with PowerPoint. So Daniel, if you can share the PowerPoint, that would be great.
Can everyone see that okay?
Yep, perfect. Okay, and I am going to go through this quickly because there's a lot of information we want to share. So if anybody has any questions, please don't hesitate to put them in the chat. And okay, so PMC, Daniel, go ahead and keep going and so PMC was established over 30 years ago. It was established as a result of a crisis, I will say, of confidence in the judiciary. There was one scandal after another concerning, the judges and elections and campaign finance. And so PMC was created as a result of a commission established by Governor Casey to help restore confidence in the courts. Go ahead. So what we do, I gave you briefly, we help advocate for judicial selection and reform, judicial discipline, bail hearing. We held a number of forums a couple months ago with the appellate court candidates. Remember, don't forget to vote in the general election in November for judicial candidates. We hold continuing civil education about the judiciary for lawyers, for judges. We hold a program in July. It's a one-day law school for journalists, but everybody is welcome to attend. It talks about It's educating journalists about the courts, making sure and helping them cover the courts. Okay. Keep going, Daniel. Michelle.
Sorry, I was on mute. As I briefly mentioned, Legal Aid is a free legal service for low-income individuals in Bucks, Chester, Montgomery, and Delaware counties, Pennsylvania. Philadelphia County has their own legal aid, which is also very good. We practice in a number of areas that we feel directly benefits communities, especially those who may not have access to justice or the money to afford attorneys, including family law, domestic violence, housing, which includes both landlord-tenant and foreclosures, bankruptcy, unemployment, Social Security, public benefits, expungements and pardons, dependency, elder law, and since I'm not sure if it's on here, children and youth services cases. We're constantly adding new areas to practice, depending on what grants we might be receiving. But if you believe anyone who may not be able to afford an attorney might need legal representation in any of these counties, highly encourage you to advise them to come to us. Worst comes to worst, they don't qualify. We can go to the next slide.
So first, we want to make sure that we put our disclaimer out there. We are not giving any legal advice tonight. We are providing you information that will help you understand the landlord-tenant process. Okay. So where do landlord-tenant disputes fit in? So Pennsylvania court system is known is infamously known as a triangle based. The bottom, the entry-level courts are known as municipal court in Philadelphia or magisterial district courts in the counties. At both of those courts, civil actions relating to controversies less than $12,000 are heard by those courts. That typically includes landlord-tenant matters. When a magisterial district court judge or municipal court judge renders a decision and one side may not be pleased with that decision, they may want to appeal. That appeal would go to the Court of Common Pleas. Additionally, if there were any actions relating even to landlord-tenant matters that were greater than $12,000, they could go directly to the Court of Common Pleas. If you're not happy with the decision from the Court of Common Pleas, it could be appealed to an intermediate appellate court, which would be the Superior Court. And again, if you're not happy with the intermediate appellate court, it could be appealed to the Pennsylvania Supreme Court. The likelihood of it going to any of the appellate courts is extremely rare. Okay. So what are tenants' rights? Federal law tells us that and Pennsylvania laws say that individuals have rights against discrimination when they are searching for homes and when they become a tenant. You know, what is discrimination, right? Housing discrimination is illegal. A landlord, a realtor, a mortgage broker cannot refuse service or change the quality of service because of a person's color, age, religion, national origin, sex, gender identity, sexual orientation, disability, or familial status. Next. So these are some examples of discrimination. So, you know, you may make an appointment with a realtor to see a house or an apartment. When you show up, the realtor decides to say, oh, that property is sold or the rent is higher than advertised. You know, there are various indicators of discrimination. So you have to, you know, that's not necessarily the only indicator, but housing discrimination is illegal. Next. So what could you do if you believe that there's been some kind of discrimination against you? You don't have to go to court, right, immediately. First, you can have some kind of inquiry. You could reach out to a governmental agency. The Department of Housing and Urban Development will take your inquiry. So will the Pennsylvania Fair Housing Hotline and the Housing Equality Center of Pennsylvania. Their phone numbers and websites are listed on these slides, and we will be more than happy to share these PowerPoint slides with you after the program. Okay, Daniel. Okay, so what other rights do tenants have, right? So a landlord can't do the following. They can't take or sell a tenant's property if they do not pay rent, right? There is a process which you will hear that a landlord has to go through in order to collect rent. But simply the non-payment of rent does not mean that a landlord can immediately lock you out, go into your apartment, take some of your property. They can't shut off utilities. They can't harass you, or harass a tenant, I should say. They need to give notice if they want to enter the property. There's not an open-ended, the landlord cannot just enter a tenant's apartment for any reason. Maybe if there is an emergency and there is a pipe break, that's a different situation. But when there's not any kind of right of a landlord to enter a tenant's property, that typically, and what the landlord should do is give the tenant notice. There are certain, requirements that the landlord could impose with respect to animals. So if you have a pet that's not an assistance animal, a landlord could say no pets allowed. However, an assistance animal is required to be permitted into as a rental property. And also, if a tenant has a disability, the landlord is required to allow the tenant to make reasonable modifications to the housing at the tenant's expense. What are a landlord's rights? Well, they are entitled to have keys to the property. They need to be able to enter in case there is an emergency. They can set rules about how the property and common areas can be used, right? They have a right to evict a tenant if they don't pay rent or they break the agreement, but they have to pursue that eviction through the court system. The landlord, and most of them do, require security deposits before you sign, enter into this lease agreement and begin living as a tenant. The security deposit is often used, right, as a safeguard for the landlord to make sure that there's no harm that comes to the apartment. The landlord is not responsible for a tenant's personal belongings in the apartment. Next. We've sort of touched this, but what are the tenant's responsibilities? The main responsibility is to pay the rent and pay it on time. But another responsibility is to obey the terms in the lease. If they include paying utilities, the tenant needs to pay utilities. If the tenant isn't paying utilities and the apartment goes into disarray because for whatever reason, maybe the pipes are frozen and they burst, that would be a problem for the tenant and for the landlord. The tenant should communicate with the landlord about repair issues. I mean, there should be a clear communication and understanding as to who's responsible for what. The agreement should say, we will discuss in a minute, but it is for everyone's best interest to have an agreement in writing. Leases don't have to be in writing, but it is best for everybody to have an understanding of who's responsible for what and what your obligations are. And at the end of the lease, the tenant is supposed to return the property in the condition in which the tenant received it. So typically that means, you have to clean the bathroom, clean the toilets, sweep the floors, make sure that there's not some old laundry in the washing machine. Okay, next. What are the landlord's responsibilities? Again, the landlord has to maintain the property in good condition. It has to be safe, sanitary, and accessible. The landlord has to make sure that drinkable water is in the kitchen and bathroom. There is hot water available. There is heat during the cold months. The landlord is not required to provide air conditioning, though. The landlord has to make sure that they provide a functioning bathroom with toilet and showers, a safe and functioning electrical system. There cannot be wires that are loose and hanging. There has to be working smoke alarms. There should not be any chipped or peeling paint. This is really important. When a landlord rents a unit to an individual with kids, there's a special concern with respect to lead paint. So the landlord needs to know that the tenant has children, and the landlord needs to also make sure that there's no lead paint in there in the housing. Next. Okay, I went ahead of myself. The landlord must inform a tenant of lead paint and lead pipes in the property before a tenant signs the lease, because this is a very serious situation, and the landlord could be sued for triple the amount of damages if lead paint or lead pipes were found and there had been no notice, I'll say, to the tenant. If the tenant tells the landlord that the smoke alarm is broken, the landlord has 72 hours to replace it. These are all requirements set forth in statutes. Next. So what is a lease? I briefly mentioned it, right? This is a sample of a residential lease here. It's an agreement between a landlord and tenant. It doesn't have to be such a formal agreement. It could be a handwritten agreement, but it is advisable to make sure that you understand the terms of the agreement, make sure that you read it before you sign it, make sure that certain key terms are provided, such as how much the monthly rent is, the name of the property, the name of the landlord, the name of the tenant, and for how long the lease will run. I mean, this is to protect yourself as well as to protect the landlord. In the lease, oftentimes there will be the amount of the security deposit and how much and when it should be paid by. The lease has to be written in plain language, meaning it's understandable. There can't be fine print that is pushed in there and has all these other requirements. And the lease can be oral or written. However, an oral lease must have less than a 3-year term. So if you're entering into an agreement with a landlord for a 5-year term, that must be written. Next. And again, here's what a lease can contain, right? It can contain the lease term, who's responsible for making repairs, who's responsible for checking the smoke alarms. Smoke alarms, remember, are mandatory. There could even be requirements in the lease about visitors, how many visitors, what time the visitors are allowed, even a requirement with respect to noise levels, who can enter the property, does the landlord require notice ahead of time, who is responsible for paying utilities, and if the rent payment is late, what happens then? What are the late charges, and how many days late does the rent have to be before late charges are imposed? This is important. In some leases, there is a waiver of notice to quit clause. It means that the landlord then would not have to give the tenant the notice of eviction and could immediately take legal action. So make sure you're aware of whether that exists or not in your lease. Next, please. Unfortunately, there are many times when landlords and tenants, end up on the wrong foot, right? But before going to court, maybe there's a way to try to resolve the matter. What's important is that if there's a dispute, as a tenant or landlord, each of you has a dispute, there should be a record of the disagreement, right? Make sure that it's written. You place your complaint in writing. There hasn't been heat for 20 days of the 30 days. Make sure that's written, because if you do end up in court, it is to your benefit that that you have evidence of it through this writing. With respect to the security deposit, the landlord has 30 days to return it. If the landlord has decided that he or she is deducting money for damages caused by the tenant, the landlord actually has to provide an itemized list of deductions from the security deposit. Again, repairs, make sure you take pictures of any kind of damages. You could file a complaint with the Pennsylvania Department of Permits, Licenses, and Inspections if there's some serious, health and housing code violation. If you have vermin, make sure you take pictures. Make sure you present that to your landlord and say this needs to be repaired. The tenant could make these repairs and deduct the cost from future rent. There's a hole in there in your wall, and that's where the vermin are coming through. But make sure that you save your receipts. It can't be something that you are doing on your own and then charging the landlord for your services. And make sure you inform the landlord that you did this. Next, please. So what is an eviction? So this is when a tenant, right, doesn't pay rent, or the lease has ended, has violated the conditions in the lease. Okay, sorry about that. And the landlord has decided that they need to move the tenant out of the property. So typically, this would then go to court, but first the landlord needs to give the tenant notice of the eviction, and then after so many days, we'll get to that slide next, the landlord can file a complaint. But again, the landlord cannot throw the tenant out without a judicial determination. Just because the landlord has filed a complaint does not mean that the landlord can now go into the property and put all the tenant's belongings out on the sidewalk. This is a legal process that we will discuss next. So Michelle, do you want to take over from here for a little? Oh, you're muted.
Sorry about that. So obviously everyone is familiar with the COVID epidemic, and it is causing an enormous uptick in the amount of evictions due to changes to the economy, layoffs, cut hours. Even people who have been receiving unemployment benefits may not be receiving enough to pay rent. And an estimated 2.3 million evictions were filed in America in 2016. That number is taking a drastic upswing. In Montgomery County, I myself have seen my number of cases for evictions almost double. An estimated 240,000 families in Pennsylvania, about 15% of all individuals renting, would be facing potential evictions or are facing them now. This disproportionately affects those who are low income, who may not have much in the way of savings, who might be living paycheck to paycheck. And vulnerable populations obviously are less able to afford legal representation, are less able to negotiate installment plans, and therefore it has a disproportionately high effect on the most vulnerable communities in our state, which is why it's such a concern for us here at Legal Aid. Next. So evictions in Pennsylvania take a number of steps, and it's important to understand them. First is the notice to quit, which, as previously mentioned, can be waived, requiring the landlord to notify you why they intend to move for eviction and a date that they want you to vacate the property. They can then file a complaint, almost always in the magisterial district court in which they reside. Then a hearing will be scheduled by the court, usually 7 to 15 days, unless something unusual is happening. At that point, the tenant will get notice of the hearing at least 5 days in advance. When the hearing occurs, it's a summary hearing. It's show up and the hearing will be held the same day. And then a judgment must be issued by that judge pursuant to that hearing in 1 to 3 days. The order of possession can be requested and served 10 days after that. That is to give the tenants a 10-day window to file a supersedious appeal, which I'll talk about more later. But that's a chance to appeal it to the Court of Common Pleas, at which point the constable or sheriff's officer will arrive to perform the eviction. You will get a notice 10 days ahead of time that the eviction will occur on this particular date and at what time. And at this point, if you do not vacate, the sheriff and constable or the police, if they call them, can arrest you as a trespasser. Next slide. So landlords, as mentioned, can only evict by valid court order, and the evictions can only be executed by the sheriff or the constable. If a landlord, even after the hearing, shows up and demands that you leave or tries to change the locks or remove you and your possessions, that is absolutely illegal, and you should call the police. You show proof that you're a tenant. That would be a lease, copies of utility bills, mail in your name to that address, whatever demonstrates that you are actually living there. You can also call legal aid services, either us if it's in one of the counties that we represent individuals in. And you can also call the Attorney General's hotline to report an illegal self-help eviction. And just to be safe, in case the landlord were to try to change the locks and lock you out, you should keep some proof of tenancy outside of your home, in a car, with a neighbor or friend or family member, or even around in a purse or backpack or something like that. Next slide. Going to court. And I think this one's back to you, Debbie.
Okay, so this is just a basic explanation, right? What does it mean when you go to court? There are all these legal terms that we as don't really understand. But if the entity or person that files the lawsuit, that's a plaintiff. The entity or person that the lawsuit is filed against, that is a defendant. And a civil suit is a private dispute. It's a matter between two individuals, business and an individual, that they haven't reached an agreement on. The court will decide whether the defendant, first the complaint is a claim by the person who files the lawsuit that the defendant has done something wrong. There will be, as Michelle said, there's a hearing. There's going to have to be proof by the plaintiff of the claims that the plaintiff is setting forth. And the proof could be the lease. The proof could be pictures. The proof could be emails or any kind of recording. But that's the proof that the plaintiff needs to show, and the defendant can then counter that with also emails, documents, pictures, and then the court will make a decision. There is no right for you to have an attorney in a civil matter. We hear about criminal matters, which are matters that are brought by a municipality, county, state, federal government against an individual. There is a right to an attorney, but in a civil suit, there is no right to an attorney. Next. So, this we've gone through this, but this explains how a case gets to court. Okay, next slide. So again, what the landlord will bring to court will be the lease, a housing inspection license, because we have to make sure that this landlord is operating validly, legitimately, operating under completing the requirements of the state. The notice of quit if the lease doesn't say that it's been waived. If there's unpaid utility bills, again, photographs, proof of payment, maybe check stubs, or bank accounts, and any kind of communications between the parties. Next. And what the tenant needs to bring, like I said, the documents to show the tenant's case. Now, the tenant could actually sue. The prior example was like a landlord suing a tenant to kick the tenant out, but the tenant could also sue for return of the security deposit. We had discussed this before, that the landlord is supposed to return the security deposit within 30 days and submit an itemized list of matters that the landlord has deducted from the security deposit. If you want to get that security deposit back and you want to file a complaint, then you need to bring with you the written lease that tells that, that shows that you had to make a security deposit, maybe even the check that showed you made the security deposit, documentation saying, I wanted my security deposit back, never got it. And any kind of correspondence that the tenant had with the landlord saying, about the itemization, right? About what the landlord has deducted. Next. So when you get to court, there's various people who are in the courtroom who has the power. And as we discussed in municipal court and magisterial courts, district courts, there are judges. They are the ones who make the decisions. Their rulings are binding. There's court staff in the courtroom. They can help you, direct you. They can help you with forms, how to fill them out. There are lawyers. Sometimes, one of the parties could be represented by a lawyer or both parties. And there is typically security entering the courtroom and security in the courtroom in order to make sure that everybody behaves properly. The judges should be treating everybody with respect. listening to complaints, listening to presentations, and making their decisions based on the facts that are presented. Next. Again, this is so we now have to go to court, and the evidence has been presented, and the court makes a decision. There is a way, if one of the parties is not happy with that decision, it can be appealed. It has to be appealed by filing a notice of appeal with the Department of Court Records. There is 30 days to file that notice of appeal if there was a money judgment entered by the court. If there was an order of possession ordered by that court, the appeal must be filed in 10 days. That's because you're concerned with, that you could actually be kicked out of the property. The notice of appeal not only has to be filed, but it needs to be served on the other side. Next slide. And similarly, if it was an order of possession, the tenant must file the notice of appeal within 10 days in order to pause an eviction. Okay. Go ahead, Michelle. Do you want to talk? Go ahead to the next slide. I think you had a slide as well. So just wanted everybody to know that judgments, if there's a judgment against the tenant, right, your wages could be garnished. They're public records. It hurts your record in trying to rent again. It affects your credit rating. So judgments are something that we need to try to avoid. Next. Okay, there.
I'm going to talk briefly about an eviction prevention and intervention coalition. This is operating in Montgomery County. There are other similar programs in other counties as pilot programs.
I'm going to interrupt you one thing. This is an amazing program, and I think that I know LASP has been really was one of the organizations that got this program up and running, and it's sitting here from PMC's point of view, when we've done these landlord-tenant programs across the country, Montgomery County really has, really is ahead of the game, I will tell you, compared to a lot of the other counties. So this is wonderful, Michelle.
Thank you very much, Debbie. I appreciate that. So this is essentially a program that incorporates financial incentives and same-day representation for indigent clients in order to prevent evictions, in order to stabilize housing and prevent clients from literally becoming homeless in the event of an issue with payment of rent or utilities or fees. It was started back in 2017 as a pilot program between Your Way Home of Montgomery County, Legal Aid, and the Montgomery Bar Association. Since then, we have expanded from 1 court to 7 within the county with plans for future expansion. The idea is that tenants who come to us facing eviction for a deficiency in payment, if they can make future payments, we'll have representation from us, Legal Aid, or other pro bono or volunteer attorneys to help them navigate the courts, which can be a little unintuitive, and to provide a single one-time grant for every 12-month period to catch them up on rent, late fees, and filing fees, with the goal of preventing them from being evicted. We're currently operating in Norristown, Pottstown, Norton, Lansdale, and Jenkintown, with potential future expansions to come. Next slide. So what will occur is EPIC staff, usually the attorney and the Your Way Home caseworker, will meet with the tenant to get information about the lease, the tenant's rent payment history, and any other issues that might be important, including how much rent is at issue, whether there is security deposit or last month's rent in advance, if there's a housing voucher or other subsidized housing issue incorporated, when the last time the client paid rent was, if there's a habitability issue, whether they've put rent in escrow and there are any repair issues, and whether the landlord has been notified. But most importantly, whether the client can make future payments. To be clear, this is not a permanent subsidy. It is not that Your Way Home will be subsidizing the client's rent payment every month. Generally, it's to catch them up on a month or a few months that they've been deficient, usually due to one-time losses such as short-term unemployment, unexpected medical expenses, things of that nature. And so far, we've enjoyed about a 70% success rate with keeping clients in their housing over a 12-month period. Next slide. So the requirements for the assistance are not that extravagant. The tenants must be at or below 50% of adjusted median income for their area. The rent relief must satisfy the current rent and utilities and late fees and everything else that are owed. It does not require that Epic pay it in full. The tenant can contribute. Right now, assistance is actually not capped due to the ERUC rent relief funds. But once that program ends, it'll be capped at about $2,000 per household. So if the tenant can make up any deficiency beyond that, that's perfectly fine. Tenant cannot have received Epic assistance for a 12-month period prior, just to prevent them from being up in front of the same judge with the same landlord every 2 or 3 months. And the tenants must agree to remain at the property, and the landlord must agree to participate with the program. It's a voluntary program. It is not compelled. Next slide. So currently capped at 2,000, as I mentioned. That is not actually currently true at this very moment, but this is an odd exception. It can be received post-judgment. So even if the client has gone to court and has a judgment against them, if the landlord agrees to mark the judgment satisfied or it's a pay and stay judgment, we can still assist. Epic pays the landlord directly by check, usually within 10 days of the agreement. And as of right now, as with the ERUC rent relief program, they can receive up to 12 months of back rent and utilities and up to 3 months of rent, but not utilities, into the future. This also does include filing fees, late fees, and potentially attorney's fees if there's already been a judgment. So it's a very unique program in conjunction with the ERUC, and I'm very happy to see them work well together. Next slide. So the rental assistance program in general, it's the Emergency Rent and Utility Coalition, the ERUC. About $852 million of rental assistance has been dispersed to the various counties. We have the name of the various counties that we work in and who to call in order to get additional information. I highly recommend anyone who may be deficient in rent, especially if it's COVID related in any way, whether because they've contracted COVID or lost their income due to the COVID shutdown, if they've been laid off or their hours have been reduced, or they're on unemployment, they may qualify and should look into the program because it costs absolutely nothing but maybe an hour of your time to apply. And this rent relief will not be available forever. I encourage everyone to take a look if they think it might apply to them or someone they know. Next slide. So the program applies in Montgomery County. This is the ERUC. Other counties have these programs as well. They're just run by different agencies and might have different names. So what I'm saying only applies specifically to Montgomery County, but there are versions of this everywhere. So tenants residing in the county at a residential property, which is any property leased for residential purposes, including private homes. The government does not apply, or the program does not apply to any hotel, motel, or what you might think of as a guest house or Airbnb situation. So it actually does have to be what you might consider a tenancy, even if there's no written lease or anything else like that that might be construed as a written agreement or a lease agreement. If you're living somewhere and you're paying any sort of money to live there, you might qualify as long as it's not a hotel, motel, guest house, or Airbnb sort of situation. Tenants must be at or below 100% of the adjusted median income for their area. They must have rent arrears and an eviction notice or notice to vacate or notice to quit at the time that they make the application. The tenants must be unable to pay the full rent and or utility arrears, and they have to report some sort of COVID-based hardship. That COVID-based hardship is very, very broad. If you're not sure if your hardship is COVID related, it might be worthwhile to apply anyway and let them make that determination. Next slide. So it offers, as I mentioned, 12 months in back rent and utilities and up to 3 months of rent into the future. Covers any arrears from March of 1st, 2020 to the present. It doesn't offer financial assistance for any arrears before then, nor for utilities into the future, since those would be highly speculative. The program, as I mentioned, can cover attorney's fees. This is very important because the previous version did not. So if you have a judgment and the judge has assigned attorney's fees, that can be covered. It also, in conjunction with the CDC moratorium on evictions, which is expiring June 30th, can get you the money while the case is essentially sitting in court. And if you're applying for financial assistance through the program, I highly advise anyone to inform both the court and the landlord, as they will not necessarily be automatically informed as to any sort of application. Next slide. Okay, these are the various programs in Montgomery County, or I'm sorry, the various agencies in Montgomery County that are running the program. I could go through them all in order, but I think it's very obvious here exactly who's participating and exactly who you should contact in your particular area. I will say if you're unsure, if you don't know who to go to, please call 211. That's Your Way Home of Montgomery County, and they can point you to the program that's operating in your area or municipality. Next slide. The CDC Declaration, as many of you may know, but some may not, the CDC last year issued a moratorium on evictions for non-payment of rent. To be clear, this does not prevent evictions for any other cause, such as breach of the lease, criminal activity, damage to landlord's property, expiration and non-renewal of the lease, or anything that you would think of aside from the actual payment of rent or utilities to the landlord. However, if someone has suffered any sort of income loss and cannot pay their rent and are facing eviction as a result, they can fill out what's called the CDC Declaration. This declaration is a 2-page document that basically states that they are unable to pay rent and they otherwise qualify, that they will be forced to be homeless or live in close quarters with other individuals if evicted. In other words, that they don't have a second residence or somewhere else to go. That they have tried to pay rent as much as possible, and that they have made less than $99,000 in 2020, that they have received a stimulus check or are otherwise not required to file taxes. I should note that the CDC moratorium has been extended several times. The most recent extension was until June 30th, 2021. So obviously that's coming up in about 21 days. It could be extended further or it may not. We have no knowledge of that at the present time. So I always state you should proceed with the worst case scenario in mind, that it will not be extended, and possibly be pleasantly surprised if that is not the case. Next slide. Now we're getting into issues with violations of the implied warranty of habitability. Basically, the landlord in the state of Pennsylvania has to provide safe and sanitary conditions. That was briefly talked about by Debbie earlier, so I won't rehash all of that. But essentially, this cannot be waived. You can't agree to an uninhabitable condition. They can't put it in the lease and you sign it and they say, you've agreed to it with the contract. No, they have to maintain habitable housing, and that cannot be altered or waived in any way. We highly recommend everyone who may have an issue document it. Make sure all the communications are in writing. Emails are admissible as well. It does not have to be a formal letter mailed by certified mail or anything like that. Pictures of the conditions itself are excellent. And the solutions, there's actually a variety of them. The first one, complain to code enforcement, or if you're in some sort of public housing or subsidized housing, complaining to the housing authority in the county that you live in. Housing authority will investigate because landlords are required to keep minimal housing quality standards, and that's regardless of the county you live in. If they fail to take action or fail to take action to the extent that you would like, or if it's an emergency issue that can't wait for an inspection, there are a couple of other options. Once you've complained to the landlord, they haven't taken any measure to repair it within a reasonable period, you can repair and deduct. Basically, pay to repair the issue yourself and deduct it from the rent. It is important you still have to notify the landlord of any intent to do any of these, to repair, to escrow, to terminate the lease. You can't just surprise them with a notice with the rent with a receipt for what you've repaired. But you must provide them a receipt so that way they can see that you've actually spent the money on these repairs. The second option is to escrow your rent. That is to place your rent in a separate account. It cannot be commingled with any other funds. You cannot deduct from it. You cannot add other money to it. It must just be the rent in full and on time paid into that account to show the court and anyone else that might ask that you intend to pay rent and that you're withholding it for a specific purpose. I do caution people that landlords tend to, rather than repair the issue, move for eviction on that basis. So be cautious if that's your option. You can terminate your lease and move out. If that premises are uninhabitable, you can just leave. Notify your landlord in writing that if they don't repair, that you intend to leave to break the lease. And essentially that's a remedy. You can also sue for damages. We see this a lot in cases where there's mold or water leaks. Some of the tenants' property is damaged, or they're forced to move out for a time and seek temporary accommodations at a hotel or something similar. You absolutely can sue for those damages. And the final is specific performance. You can sue specifically to have the landlord repair the issues. And if you are sued for non-payment of rent, at any time prior to the hearing, you can cross-file a complaint. Essentially, you can file a complaint against the landlord in response, raising these habitability issues without paying a filing fee. Next slide. So the 4 elements to the habitability defense are whether defects go to habitability. Those have been given already. I won't rehash them. Whether the defendants gave notice to the landlord of the conditions. It is important, must be in writing because it's almost impossible to prove testimony. So you want there to be no dispute that you've notified the landlord of what's wrong, of what you want repaired, and when you notified them of that. Whether the landlord has reasonable opportunity to repair the defects. This is an issue that varies depending on what kind of defects we're talking about. Obviously, something like a busted pipe pouring water into your home is an emergency issue that should be repaired within 24 hours. Maybe issues that are less severe might be something like a week is more reasonable. There's no bright line rule, so I can't give you a spreadsheet or a chart saying this is a reasonable period, but I will say gut instinct, what you think is reasonable is a good guideline. And then 4, whether the landlord failed to make those repairs in a timely fashion. The rest of these, I believe, already covered. So next slide. The Housing Choice Voucher Program, also known as Section 8. Obviously, anyone who may qualify can apply. The requirements are a little bit convoluted and a little bit beyond today's lecture, so I'm not going to give you all of that. But for anyone who cannot afford housing on their own and believes they might qualify, the housing authority of every county maintains the housing voucher program, and that you are allowed to apply for either public housing or for the housing voucher. There is a waiting list, so if you believe you might qualify, you absolutely can and should apply as soon as possible. But essentially what they do is they subsidize your rent based on your income, pay a portion of it to the landlord based on a contract that the landlord will sign with the housing authority. Not every landlord actually rents to Section 8 tenants. This varies county to county and varies municipality to municipality. So rather than get into the nitty gritty, we'll just say that it's an option that exists that you should look into if you are low income, because if you apply and are qualified, it absolutely is a long-term subsidy. They pay this every month, and it comes with additional protections, especially for warranty of habitability issues. Next slide. Okay, security deposits can be up to 2 months' rent for the first year. After the first year, the landlord is technically required to refund one of those 2 months. I will state that last month's rent in advance is a form of security. Landlords typically don't consider it to be, but the courts do. Whether or not you wish to make an issue of it, obviously I cannot advise anyone specifically here, but it is something you should keep in mind. 30 days after you move out of the property, the landlord has to return the deposit or give you an itemized list of damages and deductions. You must, within 10 days of vacating the property, give the landlord your forwarding address, however. If you fail to provide a forwarding address or contact information that they can send it to, it could be a bar to you suing for double damages. If the landlord fails to respond in writing within 30 days, essentially they've waived the right to sue for damages and you can pursue them. If they utterly fail to return your deposit or contact you or provide any written list of deductions, you can sue for double the amount of damages, or sorry, double the amount of the deposit. This is called liquidated damages. Next slide. And that's the end of everything that I intended to present. The legal aid helpline number is available here. Anyone in any of the counties that we service that thinks they might qualify for our services, either in evictions or other landlord-tenant matters, or in general, feel free to apply. At the very least, if we cannot help you, we may be able to give you a referral to the County Bar Association's referral service, Modest Means, or other programs that might assist you. And we have a list of additional resources just below, because it never hurts to have additional resources at your disposal. Thank you.
So
Next slide.
thank you. Thank you, Michelle. Thank you, Conshohocken Library. Daniel, I'm passing this over to you. And I should look in the chat. I don't know if anybody has any questions.
So far, it doesn't look like it, but if there
Okay.
are any questions at this time, we could field a few.
Well, actually, I did get one from
Great.
Jennifer. Is there a way to see this Zoom session again?
Yes, it will be recorded, or it is being recorded, and it will be available on pmconline.org, our website. And so I'll write it. Well, you're driving. I shouldn't even write it in the chat, but I'll write it in the chat. Give us a day or two to make sure it gets up there. And then we can also circulate, if we have everybody's emails, we can circulate the slides as well. Okay.
They're looking like there's no questions from participants. Well, I'd like to say thank you, Debbie, and thank you, Michelle, for hosting tonight's workshop, and the Conshohocken Free Library for allowing us to have this event with you. Thanks for everything.
This was a tremendous amount of information that we rushed through, so I understand that. So again, thank you, and don't hesitate to reach out if there are any other questions. Michelle,
And
thank you
please
so very
follow
much.
us on social media for our next workshop.
Thank you.
And thank you, Debbie, for having me. And thank you, Harry, for the library supporting and hosting us.
Yep, we
Absolutely.
are big fans of providing access to important information here at the library. So it's always a pleasure.
Great. Okay, see you next month.
Bye.
great
Thank
day.
you. Stay cool. It's hot out there.